Это у нас, кстати. Как...
Уважаемые коллеги, мне тут подсказывают, что
Honorable
стрелки на часах
colleagues,
подошли к началу
I
конференции.
got the suggestion that we are quite close to the beginning of our conference. Please take your seats at the table. Good morning, honorable colleagues, dear friends. I would like to begin our conference with an unusual beginning. Mikhail Alexandrovich gave me a gift, a birthday gift, the methodology, universal methodology of beginning of a conference. And I would like to begin with the following. Honorable colleagues, we do not expect, we're not waiting for anyone. We're waiting only for the second arm of the watch, and it is in place, so let's begin. We greet everyone at the International Scientific and Practical Conference, author in the modern ecosystem of intellectual property, and it is it goes together with the Days of Intellectual Property in the Russian Federation. And let me give the greetings on the occasion of this conference. And today our conference is dedicated to the key figure of any creative process, the person who gives his ideas for the artistic work and in the innovation products. An author can be any person, and the creative work of an author is a very important part of the scientific and social evolution of man. And the work of the author is one of the main means to overcome the challenges of the human society. And it is not possible to overestimate the role of the author's activities. Colleagues, today's system of intellectual property is closely related to the system of activities of human, and first of all, this is why we believe that in the importance of author in the digital environment. First, the protection of the rights of the author, and many other topics. And we're going to discuss them today during our conference. The international situation in the world now gives the impetus to the new inventions and the creative activities of our citizens. And the intellectual property is one of the main domains where we can conquer and retain the achievements of the Russian knowledge and science. And the pandemic that has been here for 3 years gave us the new push to our activities, and our country was the first to give the patent for the vaccine against COVID. And also we introduced the very special program from the beginning of the beginning of the pandemic, and we have already issued more than 1,500 patents related to COVID. And in Russia, the use of the results of the intellectual activities and the intellectual deliverables is very important, and we have close cooperation with different institutions and ministries, and we have the roadmap to improve the situation with the intellectual property. And this is a whole range of different benefits and incentives. We have introduced the number of benefits, and on the 16th of April, the President signed the new decree on the concession of intellectual property. And Russia is integrated in the whole international system. Last year, the treaty on the electronic system of digital system of registration of trademarks was implemented, and we have the list of companies and organizations that can provide the patent search and the use of the new inventions, and to make the system more useful for the claimant, for the author, the duty will be reduced 50%. At present, we have the work underway to improve the position of the authors, and the new changes, the improvements have been introduced into the civil code. And this is, first of all, has to do with the activities of the person who is, and this is done in relation to the activities if the author is not using the patent for 2 years. And within the roadmap that I've mentioned, we have prepared the legislative acts that will simplify the path of the rights to the workers. And also we have introduced the new approach to the commercialization of the results of the use of the patents. You know that the Rospatent is driving to the fact that to simplify the interaction between the authors and Rospatent for the granting of the certificates and the necessary evidence on the inventions. And just last month we have introduced the new system of the patent search, and this includes more than 180 million units for the independent search of the novelty of the claims and inventions. So Russian authors have very good opportunities for the preliminary assessment of their inventions. Of course, the role of authors and support of the authors, we can talk quite a lot, but I don't want to take away the opportunity from the speakers of today. We have quite wide program. We have more than 400 participants that applied for the participation in the conference, and more than 100 are going to participate on site from 47 cities, including Moscow and St. Petersburg, and also we have 9 foreign countries participating in our conference. These are our partners from Kazakhstan, Moldova, Tajikistan, Armenia, the Republic of Serbia, and others. Let me express my acknowledgement for the participation in the conference and the support to our conference, to the Eurasian Patent Office and to the International Center of UNESCO, of the Department of UNESCO at the High School of Economics, and of course to other institutions and the ministries. First of all, the Academy of Intellectual Property. Honorable colleagues, for the beginning of our conference, I would like to give the floor first for the greetings to the chairman of the Council of Federation for Science and Education and Culture, Ms. Gumerova. Dear colleagues, dear friends, on behalf of the Council of Federation and the Department of Culture and Education, I would like to greet all of you, and I would like to greet all the participants of this conference, and we pay special attention now to the intellectual property development in the conditions of pressing sanctions and very complicated international environment. And we support not only different initiatives and and this was dedicated to the development of intellectual rights. We talked about the Institution of Intellectual Property. Dear friends, we are facing a very extensive work in this sphere. Colleagues, we are now paying attention to the search of the role of the authors in the modern environment of intellectual property. We understand that author is very important, and without the activities of the authors, we would not have this institution. All the proposals on the development of this in this area should be considered. I am sure that your conference will provide a constructive dialogue and profound consideration of the new problems, and the results will provide very efficient further work, and I wish you efficient future solutions. Thank you very much, Yulia Solovatovna. Colleagues, now I would like to give the floor to Grigory Ivliev, the President of the Eurasian Patent Office. I would like to greet you on behalf of the Eurasian Patent Organization on the conference dedicated to the author. It is important that this conference is already a tradition, and it is held just on the eve of the International Day of the Book and the International Day of the Intellectual Property. I would like to give appreciation to Mikhail Fedotov, not only for the idea of this conference, but also for his energy that he shows in organizing all these conferences. This is not the first conference, and we see that through this energy and this approach, the conference becomes a traditional one. This is the first year that we have it in cooperation with the Eurasian Patent Organization, and I would like to assure you that all the countries of the region of Eurasia, Eurasian organization, will show their active participation. And it is very important to underscore the role of the author in the system of the patent law. We've been talking about author in the subsidiary participation and subsidiary rights, but we've just heard the claim of Senator Gumerova of the importance of the author. Indeed, the author of an event is a unique person. He knows something very special that nobody else knows in the world, and he forms a new idea and shows it to the whole world. Of course, author is an inventor who is able to disrupt the existing order and to give the new approaches. So that is why his rights have to be protected, first of all, in the sphere of legislation. On the other hand, the status of the invention author is not defined properly, and his rights are not protected as good as in other artistic spheres like cinema, literature, etc. And now the patent holders and the author, when we consider it, we have the rights of the author, first of all, non-material rights. Although financial and technical cooperation is not the right of the author, however, quite often we see people who are included into the patent application not properly. First of all, they are the heads of the ministries or institutions, etc. And on the other hand, quite often we have to understand that we have to, when an author is somebody who is carrying out this scientific research, and he is at the same time the author of an invention, his name should be protected. And on the other hand, if a head of an institution is the authentic author, and we have to protect their rights. First of all, when we talk about the rights, we are talking about the material rights of an author, and these are the rights for enumeration, and this is provided to the patent holder, and the author of the inventor, independent of the patent holder, have to be able to obtain the proper remuneration. We often see that very outstanding inventions of the present time sometimes do not allow the authors to get their remuneration, and this sets the problems for further activities of these authors. And when we talk about the economy of the inventions, we have to see that the inventions are the future work, the future results, and quite often we see that we have a sufficient number of individuals who cannot properly protect their rights. More than 70% of our patent applications are given by the legal entities. On the other hand, 43% from the countries of our region are applied by the individuals. And sometimes when individuals try to avoid the supervision of their employers, they try to make the claim for and to apply for the patent. According to the European Convention, the right for the patent belongs to this individual, but on the other hand, if this author is an employer, then it is dedicated by the legislation.
The statistic shows that there are national systems that provide for the safeguards, and the safeguards are not sufficient at times. And then let's look at the patent and Eurasian patent organization. So we see that the legislatures are united in their stance that yes, there are rights, and this should be carried out by public servants and officials and individuals in their capacity. So, and that's the right to invention should be vested with the employer. So, and then look at the Belarus as its jurisdiction. So we see that there are limitations imposed on officials because the employers have this right, even in the case that there is an invention that relates to the fields and also will be created based on the experience and expertise rather than the direct exercise of official functions. And if we look at it, we'll take a look at the recent trends. So we see that this the inventor should have the right to secure the ownership of the patent taker, Armenia, Kazakhstan, Kyrgyzstan, or the Russian Federation. So next we'll be looking at the rules for the acquisition of right and the passage of rights. So whenever legislators do not provide for any actions to regulate the use of intellectual products, so and let's look at the time frame. So it will be 3 months in Azerbaijan and Armenia, and then it is up to 6 months in the Russian Federation, and it used to be 3 months in the past. So obviously there is this trend in place that we want to protect the author, and we see that the employers are making their stance in order to extend the period of time not to use the invention. Then we have this further 2 months or 3 months of non-use of an invention, and this may lead to some losing of the share in the market, and then you will fail to find the right partner for this invention to be deployed. Next, let's look at the contractual background as related to the development and improvement in the Russian legislation. Oftentimes we see that those provisions that relate to the remuneration of authors as related to patents as ex officio, so in officio, in their official capacity. So then the official public servants will have to sign a contract with their employer saying that they will not claim any other form of remuneration except for the salary that they are entitled to under Russian legislation. And the reason being that, yes, so you can get your 10 to 15% of royalty unless otherwise stipulated by the contract. So this is the exact provision that we think should be modified, so that to make this 10 to 15% the mandatory part, which can be also supplemented by additional percentage. So as we have seen in the jurisdiction of Belarus, so they do have the statutory limit, and then the parties to the contract, then they need to agree on their relationship. So either in terms of the scope of supplies or the extended period of usage and ownership. So obviously, basing on this jurisdiction of the Eurasian countries, I believe we'll be able to develop a common approach toward the securing of the rights of our authors and inventors, and we'll see more inventions to come in our markets. Thank you very much for listening. And I would like to give the floor for introductory remarks to the director of the UNESCO chair. So, welcome, Mr. Fedotov. Distinguished colleagues, I'm delighted that now we can continue. So this idea of holding annual events to cover the role of authors and the role of the authorship in the system of intellectual property rights. And please note that our conference is part of the agenda, of the intellectual property agenda, that will be launched in the Russian Federation. Actually, that was launched by Matvienko, so that was done during the meeting on the 14th of April in the city of Saransk, where we held a meeting on IP issues, and currently, so we're holding the second session. So the first session was celebrated last year, and that related to industrial property in the main. So right now, so we are moving forward, and I believe that we'll be even streamlining our deliberations, and probably we will modify its title, because currently it says the author in the ecosystem of intellectual property, and then we'll just put it simply like author to 2023, author 2024, and so on and so forth, to put it very straightforward. By the way, that Archimedes conference could be used as an example. I mean, that was like event number 1, event number 2, so that's the name, the Archimedes title can stay, and then we just will add this author word to it, and the authors of years to come. So, and the author can be seen as a word that is international, because it sounds the same with Russian and in English, and so this conference actually is associated with the 23rd Eurasian conference It is held on an annual basis in April by the High School of Economics. So the conference actually is named after Yevgeny Yasin, who was a long-standing leader of the High School of Economics, because he was also one of the most prominent economists in this country. And so we talked to the organizing committee of the Yasin conference to include our conference in their associated list of events, because we are honored to be part of this greater program. And it's not the role of authors in the ecosystem of intellectual property that I'm going to touch on in my introductory remarks. I will rather dwell on it later during my keynote speech. Thank you so much for your introduction. And right now I would like to give the floor to the Deputy Dean, Mr. Larishev. So from the High School of Economics, the floor is yours. Thank you so much for inviting me, and I would like to welcome all distinguished colleagues also on behalf of the Law School of the High School of Economics. I would like to wish you also productive sessions and discussions on the authors and their role in the ecosystem of intellectual property rights. So we are truly also delighted that the UNESCO chair is a part of the organizing committee, because this is quite an experienced organization. So we have accumulated great expertise in this field, and we also glad because the conference runs as an associated event to the Yasin conference. So that has been already explained. And so we are talking about the intellectual property rights issues, and those are relevant, to many deliberations that were held within Yasin's conference, and I believe that these topics are urgent, and we welcome the idea of staging such an important event with a wider representation, where we can discuss all the issues in the so-called 3D dimension. So I'm truly impressed by this format that we see today. And I would also like to raise one point. We are doing a lot towards digitalization and public relationships. So the one issue or one question in particular about artificial intelligence. So just now you're back. Well, let me continue. So it's just the global practice that we see that there are issues relating to the authors and the authorship, or probably ownership of AI products. And we have seen cases already being tried by various courts in different countries. Take Australia, for instance, because they held that AI would be treated as a IP inventor, and then on contrast, we have the Chinese practice, and then the owner of AI would be considered as the person and entity that has the rights to intellectual products. So this could be discussed at length and through the prism of the development of relationships in the Russian Federation. So I would like to once again wish you all the best for your conference, and we'll be keeping track of all those ideas and propositions that will be made in the course of the conference. So thank you. With that, I would like to give the floor to the representative of the Federal Industry Property Institute. dear colleagues and dear attendees, so it's a great pleasure for us, to host this conference. And it's for the second time that we're hosting this event. I would like to express our gratitude to the authors of this conference and property, industrial property or intellectual property is essential to us because we also looking at authors and their rights, and also because they will give a rise to the flow of inventions, to the flow of applications that we receive, and obviously there should be this balance between the author and the right holder, and also between the patent and intellectual property products. So this is a kind of the field for our discussion that we'll be conducting together with the Russian Patent Agency and with the Eurasian Patent Organization to make sure that our discussions are fruitful and beneficial for the authors community and the country at large. So, and with that, I would like to give the floor to Intellectual Property Academy Rector Alexandra Arakelova.
Слышно, да?
Слышим, да.
Добрый день, уважаемые участники международной конференции, автор современной экосистемы.
Welcome all the participants and attendees to the conference. And we are currently at this stage and the development that requires effective measures to ensure that the intellectual property system is very attractive and efficient for all those involved in it. And obviously a person or an author will be at the center of the ecosystem, so the author that will have this creativity and also products of their imagination, creative works. And there are two events, so the first being the International Day of Book and the International Day of Intellectual Property. So these are hallmark events actually in the development of the people, the development of their authorship capabilities and the development of our civilizations. So, and just thanks to this format that we have the wider representation from the academic community, from the public sector, and also specialized experts, plus our students and IPO law students that will have to implement the decisions that we take today. So the conferences also address a wide range of issues and relating between intellectual products, the author, the society, and also government structures. So, and we are going to hear keynote speakers from prominent specialists from this country and abroad. So, and one of the sessions will be dedicated to the means of digitalization and also to the role of the author. So nowadays, and now we know that more than 100 people have already registered, so from the academy as well, from the technological parks, and also students and fellow scholars, practitioners and lawyers and economists. And it's my hope that for our conference attendees and participants will be of great use of those solutions put forward by our key speakers in order to further develop the IP ecosystem. And I would like to invite you to be as open as possible in our dialogue, and also I would like to ask our students to urge them to be very mindful of all what is happening today, what we're talking and discussing now. So thank you so much, and as has been already mentioned, our actually event is dispersed several venues. So as we have several locations in place, and we have many participants contributing to our discussions. And now I'd like to make an announcement. So this year, there is one major initiative on the way. So it is this new competition that we want to launch for a successful patent. So the competition or the contest will be organized in order to attract businesses and scientists and academists, and also attract their attention to raising the awareness and the level of knowledge, and also in intellectual property, and also broadening the opportunities for a commercial application of intellectual products. And we'll be looking at patents for inventions. So it was last year that we held a competition, and we received more than 100 applications from 21 regions of the Russian Federations, and we believe that it can be taken as an indication of a good start for the new project. So there's a high level of interest actually, and it is a positive trend in the understanding and the realization of the right of intellectual property in the modern world. And obviously this is one that can be seen among Russian businesses and inventors and scientists. So far we have selected 8 successful contenders, and today, so in this among us, so we do have representatives of this group. So those that have been awarded, and I remember that the selection process was tough. I am happy to award diploma certificates to the successful contenders, and now I announce the ceremony open. So Olga Grigorieva is awarded as a member of the Lomonosov University for treating the fibrosis techniques based on cells. Next, Anna Kornilova from Kazan University. So, and their invention relates to cell therapy. So next, I would like to invite the author, Vladimir Tikhonov, and we want to also award this diploma certificate to the Aviation Institute named by Gromov, so for their invention relating to the aviation engines, and also providing the stand or like the testing ground for the aviation exercises. Next, I would like to invite the author, Christopher Gentimirov, and that's the Research Institute construction that will be awarded for the polymeric and structures in construction use. Next, I would like to invite Bogdan Lekchenko, who is the director of BV company, and that's the invention that relates to the beer. So production, actually producing the substance which is rich in protein. Sergei Parikarov, who invented the table that can be transformed into many shapes. Next, I would like to invite Elena Belikova, and we want to award what is the company, Pavel, so for the digital radio communication systems. Next, I would like to invite also the co-author, Alexei Sidorov, and the award goes to Headhunter for their invention, for the recommendation, and also a personal matching based on big data. And these are laureate diplomas as part of the successful patent competition, and also certificates for further training. So first we want to invite Sergei Kulit from quantum physics and also Alexei Odinokov. And we want to give this award to the Moscow State University, named after Lomonosov, and for their invention in quantum field, and also connections and attacks. Dear colleagues, I'd like to take a bit of your time. That's quantum technology. So actually that we are researching and studying, it's like, if you draw a comparison between chess and soccer, I mean, just, the chess no one understands, but they play actually in soccer, they do play, but they don't understand a lot. So the quantum, science is something that go through fundamental science to the application of our inventions, and we are producing these regulators, and now we have started manufacturing of the units, so hopefully they will be used very soon in the market. So I would like to thank our partners, I would like to thank the manufacturer that invested the trust in us. Thank you all. Next, I would like to invite Igor Panfurov. So the Institute for Railway Automation and Information, and the award goes for the invention for train traffic regulation. Now I would like to invite Alexander Vichenevsky, and that's the Research Institute from the Health Care Department. So we would like to award the certificate for the medical invention surgery.
For the nomination with diploma, co-author Sergei Toshkayev from the Novosibirsk Institute for the special therapy of malignant tumor treatment innovations. The author of the invention, Elizaveta Karskaya and Inna Dolzhikova, are invited for the diploma from the Center of Epidemiology, named after Gamaleya, for the invention of specific immunity induction against COVID-19. Anastasia Volkonskaya is invited for the diploma. The company's innovations is nominated for the invention of superconductor, flexible superconductor, and its application. Marat Ilyasov is invited for the invention, the training equipment, vertical roll cart, and the methods of training or using this invention. Good morning, honorable participants and organizers of the conference. colleagues inventors. I'm very happy to be here and to obtain this high award. This is a great honor for me. With your permission, I would like to express my gratitude and appreciation to our president, Vladimir Vladimirovich, the head of Rospatent, Yury Sergeyevich, head of FIPS, Oleg Petrovich, and the whole crew of Rospatent for the organization of this very important conference. 15 years ago, I got into an accident. I was paralyzed, and after training and special approach, I invented author's training equipment. And now, with the support of the president of Tatarstan and the general director of Tatneft company, we help all those in need to improve their movement activities. The idea of the invention of the training equipment appeared while having exercises, and I faced that I could not provide the full amplitude of my joints. So I I decided to invent different training equipment to provide this movement, and I prepared 12 useful models, and part of them are patented. And also, I would like to express my appreciation to Tatiana Yerevantseva, Deputy Director of FIPS, and she was my tutor. She taught me to provide the search of the patents, to prepare application, etc. I wish all of you very strong health and well-being in all your activities. Thank you very much for your attention.
Для вручения диплома приглашается Елена Валентиновна Письменная.
Елена Письмена is invited for the diploma, and her company Exoatlant for the special approach of the use of exoskeleton for the users. With your permission, I would like to say a couple of words. Thanks to all the organizers of this conference. It is very interesting for us to see all of you and our colleagues, inventors, and also this provides the creation of the area and air of creativity. We understand that society gives us support, and this is not that we sit on our own and trying to invent something. And here this gives us opportunity to meet persons to whom we want to help, and we're going to cooperate even in this. And we support also even children. Thanks again to all organizers. And now we invite the author of the invention, Igor Paderin and Igor Shell, and the award is given to Gazpromneft NTC company for the new approaches in the development of oil wells with hydrofracking. Thank you very much for this opportunity. I want to say that this is a very important conference because our patent is very successful and very important. And as a matter of fact, the author normally does not receive anything besides his standard salary. And for us, it is very important to see that we were given attention. This is not the COVID vaccine, and our invention would not get the attention of wide. sphere of users. But nevertheless, our patent indeed had drawn attention, and on behalf of the oil business, we would like to express our appreciation that because our patent will serve not only for our industry but also for other industries. And probably it is not seen from the application, but many our patents are related to the IT sphere, and the method of approval of the patent is very important. Now we have to know how to write patents and applications, and what we should be concentrated at. And it is important to mention that our patents are related to the real life. And we take actually the decision, and this is the solution, how to optimize the oil production and how to save money. So once again, thank you very much for this acknowledgement. Thank you, friends. We have summed up the results of our competition. Well, I want to point out that Marat was very concerned that he's taking the time of our conference, but I want to say that, Marat, you are the author and you are the inventor, and you actually speed up the development of our country. And it is very important that in the present difficult and complex conditions, you try to develop our import replacement technologies. And you are very insistent in this, and once again, thank you very much. And your activities will be highly appreciated and supported. Once again, I would like to give you applause. And let us continue our contest. And now I want to pass immediately to the next stage of our conference, to the plenary session. Unfortunately, we're behind the schedule. But nevertheless, we hope that our speakers will be in time and observe the timing. The name of our plenary session is the Bermuda Triangle, the intellectual property, the system of relations between the authors and the holders of the intellectual property results, the legal rights holder, the user, the consumer, the society, and the state. And today's topic is related to the central figure, the author, and those who are in the foundation underlying our intellectual property system. And I would like to give the floor to the first speaker, Mikhail Fedotov, and his presentation is called On the Way to Form the General Theory of Authorship. Good morning, colleagues. I would like to present to you some preliminary observations related to the general theory of authorship. We're not talking only about the authorship and the patent law, but of course, about them also. We know that any result of the patent activities possesses its author when the invention appears. And as I spoke at the last conference, even in many means of individualization, the author plays a special role. And this has to do not only with the trademarks, but with the commercial names and other types of commercial marking, but only when they have to do with the creative activity. We know very well that a trademark can be very original, very authentic, very well remembered. On the other hand, it can be not noticeable, however, not having the confusion aspects with other trademarks. On the other hand, the result of the individual invention can be registered, and when we talk about the authorship as the key element of the theory of intellectual property, I think that the theory of authorship can later grow to the meta-theory of the great theory of intellectual property, and in turn this will be the system of knowledge about the exclusive rights for the intellectual objects, about subjects and objects of this law and the mechanisms of the legal protection and methods of and the means of legal protection, etc. At the last year conference, in order to prove the authorship, the ancient character of of authorship, I showed the ancient Greece vase. They are here in the bottom of the slide. But now I want to give you another example. As an Italian philosopher Seni mentioned, when Homer was passing through the Greek countries, singing his verses and receiving hospitality, he introduced his authorship, and this was the first author right paid to the greatest poet. And if the occurrence of authorship is related more to the history of author, then the appearance of the author is quite modern. And the authorship and the author are the coupled categories in the theory of intellectual property. The existence of the author is proved by the existence of the results of intellectual activities. Intellectual deliverables can not exist, but if we have the results, then it is the proof of the author of authorship. And it is important that the inventions, the greatest inventions in the history of the mankind, do not have author. Bible and the wheel. We know we have heard the mentioning of the book where Moses were introducing his notes. We can imagine that the notes about Moses was done by the Moses himself, but he could not make the notice of his own death. We have to understand this not in the European approach, but we have to take into account the Eastern approach. And in the East, there were no the authorship of the literary works. But we have to mention that the existence of the author is proved by the results of the intellectual activity. The results of intellectual activity is the implementation and embodiment of the author's ideas. And the invention is is considered to be done when the idea of the author is implemented. And at least there are two stages, the conception and implementation. And the creative contribution is the individual contribution of the author. And we know that the artistic work is done by the author, and this allows us to see the difference between the caster, the sculptor and the artist. And we know that the implementation system as it was mentioned by Viktor Dozortsev, and it is important to understand that this is related to the registration system. The registration system certifies the authorship but does not presume it. And it is important to mention that the civil code does not define the results of the intellectual activities, leaving open the concept of intellectual activity and creative work. So, which activity is creative and which is intellectual? The social system presumes the authorship but does not confirm it. But the registration system confirms the right but does not presume it. We can imagine that these are the two sides of the belt. And it is so-called Mobius Strip or Mobius band. It is done it can be done very easily by any person. If you take a band and you put it the ends together, crisscrossed, and then you will have the Mobius strip with only one side. We know that every thing has two sides, but in the Mobius strip we have an object with only one side, and the Mobius strip can allow us to model the creation of the results of intellectual activities. At first, we can say that the writer on the top of this picture and the reader below on the bottom side of this picture and can be on different sides, but the Mobius strip shows that they are both on the same side, because an artistic work is created not by the writer but also by the reader. And if the reader does not see the results of the creative work, then it means that the invention would be only in the mind of the inventor. And this is not sufficient for the activities, for the commercial use. And it is important to mention that we see the different sources of invention in different areas. And Denis Diderot, the French philosopher, says that if a person does not own the creation of his mind, the unique offspring of his studies, research and native vigils, the fruit of long studies and observation, if he does not own the most wonderful hours, the most wondrous moments of his life, if he does not own his own thoughts, his heart trouble, the most important particle of himself, then what belongs to him? Who, if not the author of himself, has the right to dispose of his creation, giving it as a gift or selling it? Mental work in itself brings a very small income, and if there is no income at all, who wants to think? Only those who are endowed by nature with the irresistible craving for this occupation, forcing them to despise poverty. But are there many such enthusiasts in the world for whom even bread and water is sufficient during the day, and only a lamp at night? And should the authority bring them to such a fate? If they decide to do so, how many thinkers will we have? And there are two conclusions. First, indeed, the invention belongs to the man, and the authorities who have to provide the material support to the author and his family.
Представление об авторстве как естественном праве в XIX веке развили немецкие правоведы Brünchli и Ordzhonikidze.
Brünchli and Ordzhonikidze in the 19th century invented the different ideas in 19th century. And they used to say that there is a close relation between the author and its product, as like between the product and the creator. And Mr. Ortlov would say that the author, the right of the author is the natural expression of the individual person. And the legislation can do changes, but cannot boast that it has created this institution. Also, the international the authorship was reflected in the Universal Declaration of Human Rights and in the International Covenant on the Economic, Social and Cultural Rights. And these two documents underscored the importance of the participation in the cultural life and the right to protect the moral and material interests. Mr. Shershenevich, an outstanding Russian philosopher, provided the systemic approach to the author and authorship. He said that an artist who conveys on the canvas an image that is being carried before him, a poet who expresses his excited state in harmonizing words, a scientist who sets out an idea worked out in a book with a series of logical conclusions. All of them find the highest satisfaction in the very act of creativity. The only thought that occupies them and eliminates all other considerations is the implementation of their ideas in practice. This noble goal gave a special charm to many poetic works, aroused attention and sympathy for many learned works. Intellectual worker is motivated to his work by internal stimuli arising from his spiritual needs, but not by material consideration. And all in all, it is more important to find out the economic basis of the institution of copyright, since law is a means by which a certain social goal is achieved, and therefore the use of a means law must be conditioned by a goal set. From their private point of view, the authors are inclined to limitless expansion of the limits of legal protection of their property interest. This was said by Gavril Shershenevich, an outstanding philosopher. And that's why we can say that it is very important to provide self-expression, second, self-affirmation and self-esteem. Let us recall the words of the famous Russian poet Pushkin, "I wish the glory." Third, self-implementation and realization. And finally, the property interests. Except for the last one, all the first three motives are related to the freedom of creativity. If we consider the activity of the rights of the author, he was saying that the work of a doctor, or of a lawyer, of a teacher, is not only the services, but also an intellectual activity. But what about the results of the work of a doctor? Are they the results of the intellectual activity? In what case the doctor can be acknowledged as the author? Shershenevich wrote that the law established in the favor of doctors the exclusive right to provide the medical services. Similarly, the lawyers are given the exclusive right to provide the help in the court. And all these rights are combined in the new group. And this includes authors, authorship, the creative, musical rights, the privileges for the industrial invention, the rights for the company, for the factory and trademark, and this category will be growing further on as long as the complication goes of the existing economic system. But at the same time, Sherchinevich was saying that if we have the creation of new exclusive right, on the other hand, the life already rejects the outdated forms of the rights, and this includes different feudal seniorship rights, the rights of the landholders, and, for example, the exclusive rights to sell horses or pigeons or wine production, beer, etc.
And then so a brilliant attempt at systematization by the Victor Dozortsev. It's a Russian scholar that actually the author of the fourth part of the Civil Code. And Professor Dozortsev then cited that that scheme was a bit erroneous. However, it does describe the system of exclusive rights, so which you can see on the screen. And I'd say that this scheme compares to the periodic table. And relying on that, we can continue the work that was started by Mr. Dozortsev, because also he was one of the founders of UNESCO chair, the High School of Economics. So we are just looking at his methodology, and we see that he wanted to single out the origin of intellectual property, and that the authorship was taken as a method notion, though he did not use it in his lexicon, but he emphasized that it just there's sharp increase in the scope of protection through exclusive rights, and there are new areas that often require new means of protection, and there's the common thing that needs to be in place, to safeguard the system, and we do have these common oranges that would cover all the type of exclusive rights, so there are specific groups. Just in the absence of such common origins, then we'll see this very selective nature and also lack of protection and efficiency in their operation. So as for the identification and the selection, this will rely by the market situation rather than the nature of relationship. So that was what he wrote, and then he gave this software protection as an example for literary works protection. So that was the last century that the mechanism actually was developed by WIPO. So it was Volner that he suggested that we would take the computer memory, like a reproduction, and then whenever this is displayed, this can be seen as a display, and therefore software can be equated to this creative work, such as screenplay. So whenever it comes as very authentic, then it needs to be protected as a literary work by copyright. And as a result, we see that contemporary system of software protection as literary works, and this has been enshrined both at the international and domestic levels. And as a result, so we may find ourselves in this situation, so where we take the software that is seen as a literary work, but then it produces some sounds, or produces another kind of work that would be musical production, and then the way that we categorize the process, because we see that artistic or literary versus musical, and then this, what is derivative, because obviously we take music and it has nothing to do with the software, so neither in its format nor in its content. So these are just all these consequences that we may face whenever we see that the wrong chosen format. So let's go back to the intellectual product, and that requires novelty and also and originality as applied to promotional designs and topologies. Next, novelty on inventive level, and again as applied to inventions, and then we see novelty, uniformity, and stability, sustainability for breeding achievements and commercial value for know-how, and that has nothing of importance for copyright, because the copyright is centered on the work, and no matter its qualities or characteristics or means of expression. So we're looking at the list of works, so this list is open, and then the notion of work has not been spelled out in legislation. So it's, again, this Mobius ribbon with one side only. So the author is there, it gets duplicated and dissolved, and the author is disappearing. So it's a kind of immersive core working, so against the background of most advanced technology, and we see that the intellectual products, they get diluted with less definitive borders or contours, and then I believe that the intellectual product only comes as a tangible result when we see that the author believes that his work is completed. But from the point of view of the consumer, of the user, of the reader, so they would take that product as the one that can be used by other people. And just if you buy a painting, then you need to go to auction, and if you want to know the true value of it. It is the copyright and related rights are important. Let's take a look at France. It was prior to 1925 that all these artworks had to be deposited with the National Library. So that depositing actually gave rise to copyright. In the United States, there is the Copyright Office at the Congress Library, and it works for the registration. So once it is registered, then it is very simple to differentiate between a simple photo and a photographic work. And then you take this child's drawing, and this can be also distinguished against something more professional. And so we are talking about the commercial value and also at this very notion importance that is being attached to it by the author. So the copyright system needs no duplication of the patent one, so there's no need for expertise, it's by way of notification. So and this mechanism is very convenient, because you can also tell who is who, I mean the author, whether he's real or he's writing under a title. We all know that Alexandra Dumas also gave his works to other people so that they could publish them with their names, in order to promote his pieces. And we do know that there are instances where we would see officials included in the list, and then the client itself, for example, himself or herself, could give you an idea of a screen just or one idea or story behind it. For instance, Google told that Dead Souls were inspired by Alexander Pushkin, but no one will take Google's copyright for this. Google's novel, ideas, they are not protected by copyright, but this is not a full stop to this narrative. And please, I would like to draw attention to one case that was tried in China, and that was Tencent Corporation as a plaintiff, and the robot actually produced a Dream Writer software in 2015 in order to produce digital news about exchange developments. So, and then the financial report produced by the software was posted that included Shanghai Index and currency rates, also information on assets, movements, and then the Shanghai technology company actually copied that report and posted it on its own site. So the Shanghai technology is a respondent, so they posted the report without seeking any consent or permission from the Tencent. Hence, litigation started, and actually the court ruled in the favor of the plaintiff, saying that just these can be equated to the written piece of work and based on analytics, and it is also very straightforward and it is logical. Again, the text is unique, and this level of identification is also quite visible, hence. So ergo, and this text can be considered as the subject matter of copyrights. And Professor Dozortsev wrote that the results received from the functioning of technology or technical means are not protectable. And yes, I'd agree with that, because just artificial intelligence and software, so they operate and function. But if we take this text generated piece, so this can be seen as the subject matter of copyright, then the software producing the text would be seen also as an actor in intellectual property, then, but an actor can be only an individual. And then what we take is we just say that the software then acts as an individual, and that's quite an absurd logic. So I would like now share some conclusions. You see, the task of the general theory of authorship is to systematize the knowledge of the subject matters of authorship, so their motives and forms, intellectual activity, and also protection of legitimate interest of authors in order to strike this balance of interest among authors, copyright holders, users, consumers, society, and the global community as a whole. So in order to identify gaps in their knowledge, and suggest solutions to bridge them. And there's this principle that all tangible products, I mean, they can be freely used by all people without any concept, unless so there are cases stipulated by the law. Then we're talking about the protection. The protection can be dictated by the law only, and to me that's the role of law should not be limited to the protection of exclusive rights only. So it works to the purpose of just promoting authors and motivating them and incentivizing them, perpetuating them, inspiring and encouraging them. So at the same time, I would agree to this statement that these legal mechanisms should work only in the relevant field and to protect the interests that relate to it. And thank you so much for your very extensive, such fundamental review. And I would like now to give the floor to the professor of Illinois University, the United States, Peter Merks. So would you like to first introduce our keynote speaker? He's a good friend of yours? Sure. So Professor Max actually is a member of our UNESCO faculty, and actually he is one of the most prominent and knowledgeable specialists in intellectual property, so especially in Russian Federation, and he has taken part in multiple IP litigations, and both international arbitral centers and also in the judicial systems, and he has authored many works and literature on intellectual property. It's just this, distance, because we're in Moscow and he's in Illinois in the United States. Probably time difference actually will allow him to join our discussion because we will be able to ask questions, and I would like to invite you to listen to his responses, because, as I said, he's very, very rich experience and very high-level expertise, and many students across the world. So thank you so much. And now we have 20 minutes for Professor's keynote speech.
Прежде всего, хочу поблагодарить организаторов за возможность принять участие в конференции. Сегодня я хотел бы поделиться мыслями о будущем права интеллектуальной собственности. Известный американский бейсболист и популярный философ Йоги Берра сказал: «Трудно делать прогнозы, особенно о будущем». Именно поэтому говорить об этом весьма опрометчиво сейчас. Я хотел бы обсудить две основные области интеллектуальной собственности. Одна из них способствует творческой деятельности и привлечению инвестиций, а вторая содействует повышению качества продукции и облегчает потребителям процесс поиска. Некоторые отрасли законодательства в сфере интеллектуальной собственности, например, патентное и авторское право, нацелены на стимулирование творческой деятельности путем предоставления исключительных прав. При этом такое стимулирование основано на создании монопольных прав, что в свою очередь приводит к сокращению производства. Поэтому необходимо обеспечить надлежащий баланс между преимуществами стимулирования творческой деятельности и недостатками монополии. Другие объекты права интеллектуальной собственности, например, товарные знаки, географические указания и наименования мест происхождения товаров, удостоверяют качество продукции и упрощают процесс выбора для потребителей. Однако данные виды интеллектуальной собственности также требуют поддержания баланса между исключительными правами с одной стороны и преимуществами конкуренции и свободы слова с другой. В этом выступлении я хотел бы обсудить дисбаланс, который уже существует или только возникает в законодательстве об интеллектуальной собственности, а также меры, которые уже принимаются или могут быть приняты для его устранения. Патентные портфели продолжают увеличиваться. Сегодня компании Apple принадлежит около 18 тысяч патентов. Через 17 лет срок действия почти всех этих патентов истечет. При этом Apple регистрирует примерно 2700 патентов в год, то есть такими темпами за 17 лет компания сможет накопить около 46 тысяч новых патентов. Постоянно растущее число патентных заявок усложняет задачи патентных ведомств по обеспечению выдачи патентов только на действительно инновационные изобретения. Такие обширные патентные портфели серьезно затрудняют выход на рынок небольших начинающих компаний, которые часто лидируют в сфере технологических инноваций. Таким небольшим компаниям придется потратить большую часть своего стартового капитала на оплату услуг дорогостоящих юристов, которые проведут их по патентному, так сказать, минному полю. Им также потребуются средства для оплаты лицензий на патенты, которые преграждают им путь на рынок. Между тем, крупные, прочно обосновавшиеся на рынке компании с обширными патентными портфелями и большим количеством штатных юристов находятся в гораздо более выгодном положении для преодоления преград на пути к инновациям. В частности, они могут обменять свои патенты на нужные им лицензии или оспорить выдачу патентов с помощью своих опытных юристов. Развитие законодательства и правоприменения в некоторых странах ослабило негативные последствия внушительных патентных портфелей некоторых компаний, но на международном уровне предстоит еще много работы. Верховный суд США отменил доктрину, согласно которой за каждое нарушение патента должно выноситься судебное решение о запрете, и заявил, что размер компенсации должен основываться на вкладе изобретения в конечный продукт. Еще одно серьезное ограничение относится к справедливым, разумным и недискриминационным условиям лицензирования патентов, формула которых основана на техническом стандарте. Международные стандарты приобретают все большее значение в 21 веке, особенно в концепции интернета вещей, где функциональная совместимость имеет первостепенное значение. Некоторые страны предоставляют правовую охрану полезной модели, объекту интеллектуальных прав, которые относятся к улучшению или модификации технического решения, но не обладают изобретательским уровнем, необходимым для регистрации и выдачи патента. Другие страны, например, США, где Конституция требует наличия изобретательского уровня для регистрации технического решения в качестве изобретения, не предоставляют правовую охрану полезным моделям. Перед нами стоит один важный, но нерешенный экономический вопрос. Должна ли существовать промежуточная форма охраны полезных достижений, которые не отвечают требованиям патентоспособности? Можно утверждать, что компания, которая первой выходит на рынок с тем или иным изобретением, тем самым приобретая фактически кратковременную монополию на рынке, обладает достаточным преимуществом, чтобы стимулировать незначительные достижения и разработки. Учитывая принципиальные разногласия по данному вопросу и трудности получения объективных экономических данных, маловероятно, что в 21 веке произойдет некая международная гармонизация в области правовой охраны полезных моделей. Государство охраняет внешний вид товара путем выдачи патента на промышленный образец или регистрации дизайнерского решения. Несомненно, поддержка не только полезных, но и красивых товаров крайне важна. При этом существует ряд сложностей, связанных с предоставлением правовой охраны внешнему виду. Одна из проблем наряду с внушительными патентными портфелями полезных моделей заключается в том, что обширные патентные портфели промышленных образцов могут создавать определенные препятствия для выхода на рынок мелких конкурентов. Еще одна проблема, которую государство решает различными методами, связана с запчастями, для которых клиенты должны покупать детали, подходящие конкретно к их автомобилю или другой технике. Множество новых вопросов может появиться в отношении регистрации патентов на живые организмы, в частности, сложных этических и практических вопросов, связанных с генетически модифицированными людьми. Я только что упомянул о некоторых проблемах в сфере правовой охраны запчастей, таких как крылья и карбюраторы для автомобилей. При этом появление возможности создания человеческих протезов или органов вызовет еще больше вопросов. Масштабная замена бумажных и иных физических носителей на электронные привела к кардинальным изменениям в законодательстве, регулирующем охрану коммерческой тайны. Воры и недобросовестные сотрудники больше не измеряют отдельные детали линейкой, не фотографируют чертежи технического решения и не крадут несколько бумаг из картотеки. Они загружают терабайты компьютерных программ и данных. Еще одной проблемой является увеличение количества краж коммерческих тайн, начиная с индивидуальных попыток обиженных сотрудников и заканчивая скоординированными действиями государств в условиях постоянно усиливающейся экономической конкуренции. Значительно увеличивающиеся масштабы краж коммерческих тайн, а также возрастающая роль национальных разведывательных служб привели к более активному правоприменению и, к сожалению, политизации охраны коммерческой тайны. Законодательство о коммерческой тайне создает особые проблемы для предприятий, действующих на разных рынках, так как трудовое законодательство, а также критерии охраноспособности коммерческой тайны значительно различаются в разных странах. По моему мнению, в законодательстве об авторском праве существуют 4 основные проблемы. Первая проблема связана с так называемым неожиданным нарушением авторских прав. Такое нарушение может произойти либо из-за неправильного понимания сложных правил или соответствующих фактов, относящихся к авторским правам, либо чаще всего из-за загрузки материалов в социальные сети или на другие веб-сайты, нарушающие авторские права. Продолжаются споры по поводу того, кто должен проверять загруженные работы – владельцы авторских прав или интернет-хосты. Вторая проблема связана с произведениями-сиротами. К ним относятся произведения, находящиеся в общем доступе, статус авторского права, которых нелегко определить, а также защищенные авторским правом произведения, владельцев которых нелегко установить. На мой взгляд, всеобщее принятие Бернской конвенции и ее закрепление в соглашении Всемирной торговой организации по торговым аспектам прав интеллектуальной собственности было большой ошибкой. В частности, это породило огромное и постоянно растущее количество произведений сирот. Возможный компромиссный подход к произведениям-сиротам состоит из нескольких этапов. Некоторые из них не требуют внесения изменений в Бернскую конвенцию. Для реализации же других может потребоваться ее пересмотр, что в свою очередь является чрезвычайно сложной задачей. На самом деле, некоторые шаги уже были предприняты в Соединенных Штатах. Многие страны Европейский Союз в настоящий момент рассматривают и будут продолжать реформы для решения проблемы произведений сирот. Третья проблема связана с распространением авторского права на охрану программ для ИВМ и программного обеспечения. Такая охрана противоречит давнему принципу, согласно которому к авторскому праву относятся только литературные и художественные произведения, а произведения, имеющие полезный функционал, должны охраняться патентами. И только в том случае, если они содержат необходимый изобретательский элемент, то есть обладают изобретательским уровнем. Такие произведения охраняются в течение относительно короткого срока после раскрытия. В случае охраны с помощью патента ничто не мешает другим предприятиям создавать устройства, совместимые с запатентованными устройствами, или ремонтировать их. Однако авторское право может препятствовать такой законной и полностью независимой работе. В Соединенных Штатах, как Конгресс, так и суды, установили некоторые ограничения на чрезмерную защиту авторских прав, но при этом многие проблемы остаются как здесь, так и в остальном мире. В недавнем деле Google против Oracle Верховный суд Соединенных Штатов дал широкое толкование принципу добросовестного использования, закрепленному в законе об авторском праве Соединенных Штатов. Это было сделано для того, чтобы разрешить Google копировать более 10 тысяч строк кода Oracle для языка Java с целью обеспечения совместимости с программным обеспечением Google для Android. Однако не совсем ясно, придут ли другие страны к такому же результату в случае, если их законодательство ограничивает добросовестное использование каким-либо конкретным перечнем. Четвертая проблема связана с ограничениями доступа к зашифрованной и защищенной паролем информации, охраняемой авторским правом. Хотя такие ограничения в значительной степени помогают в борьбе с пиратством книг, музыки и видео, они также ограничивают традиционно разрешенное использование защищенных материалов. В будущем конфликты интересов между правами интеллектуальной собственности и конкуренцией в таких распространенных областях, как мобильные приложения и самостоятельный ремонт автомобилей, будут становиться все более и более значимыми. В 20 веке была осуществлена успешная попытка упрощения процесса международной регистрации товарных знаков и расширения их охраны. Мадридская система упростила и снизила стоимость регистрации товарных знаков в нескольких странах. Идея защиты товарных знаков от размывания при использовании знаков в отношении разных видов услуг, впервые получившая широкое распространение в Соединенных Штатах, была также распространена по всему миру в соответствии с пунктом 3 статьи 16 соглашения ТРИПС. Две другие области законодательства о товарных знаках, вероятно, будут иметь важное значение в 21 веке. Первый предполагает разграничение охраны товарного знака и патентного права. Товарным знаком, охрана которых при соблюдении необходимых формальностей может сохраняться вечно, не должна быть доступна охрана полезных свойств продуктов, то есть их промышленной применимости. Такие функции должны быть защищены только патентами, что означает, что охрана должна требовать изобретательского уровня и должна быть строго ограничена по времени. Разграничить правовую охрану товарных знаков и патентную охрану достаточно непросто. Например, это привело к широкомасштабным судебным разбирательствам в Соединенных Штатах. До сих пор не существует единого международного подхода к решению этой проблемы. Разработка такого подхода станет сложной задачей в 21 веке. Второй вопрос касается разграничения правовой охраны товарных знаков и свободы слова. Следует ли отказывать в охране товарных знаков, оскорбляющих некоторых покупателей, или предоставить правовую охрану товарных знаков, оставив решение проблемы на усмотрение рынка и клиентов? Будут ли они настолько оскорблены, что не купят данный продукт? Насколько свободно должны чувствовать себя критики и конкуренты, негативно высказываясь относительно товаров с отсылкой на товарный знак? Мнения по этим вопросам расходятся, в результате чего в разных странах по-прежнему существует множество различных подходов к нормативному регулированию. Далее я хотел бы затронуть вопросы, тесно связанные с основными положениями международного права в сфере интеллектуальной собственности. Я думаю, что неважно, относятся ли эти области к интеллектуальной собственности или нет. Важно то, что многие проблемы, возникающие в 21 веке в этих областях, затрагивают те же вопросы, которые уже обсуждались в отношении интеллектуальной собственности.
With these areas raise the same questions as I have discussed with respect to intellectual property.
Доменные имена имеют много общего с товарными знаками. В деле Booking.com Верховный суд Соединенных Штатов постановил, что доменное имя может функционировать как товарный знак. К сожалению, развитие системы доменных имен в интернете привело к нарушению основного принципа закона о товарных знаках, поскольку конкуренция может процветать только в том случае, если все конкуренты могут использовать общие названия своих продуктов. Универсальный принцип закона о товарных знаках заключается в том, что никто не может обладать правами на товарный знак в отношении родового понятия продукта или услуги. Никто не может иметь действительный товарный знак для всех отелей или погоды. Однако, в порядке времен золотой лихорадки доткомов проницательные спекулянты захватили 1000 общих доменных имен доткомов, таких как отели.ком и погода.ком. Право на публичность, то есть исключительное право физических лиц разрешать использование своего имени или личности в рекламных целях, признается в Соединенных Штатах на протяжении десятилетий. Это право служит важным стимулом для артистов и спортсменов. В Соединенных Штатах это право признается в большинстве штатов общим правом, законом или и тем, и другим. Однако ситуация остается неясной в других странах. Проблемы возникли в связи с использованием высокооплачиваемыми профессиональными менеджерами права на публичность спортсменов-любителей. В 21 веке много вопросов относительно этого права остаются нерешенными. С точки зрения экономики, право позволяет знаменитостям увеличить свой доход за счет своего образа, но при этом избегая как недостаточного использования, так и злоупотребления. Это побуждает их усердно трудиться, чтобы имя работало на них. Теория естественных прав предполагает, что каждый человек должен пользоваться преимуществами своих достижений, такими как, например, усилия, необходимые для достижения успеха в спорте. Но является ли обогащение без того богатых людей подходящей целью для правовой системы? Следует ли давать бездарным, но симпатичным людям возможность превратить свою внешность в деньги? Должны ли люди с обычной внешностью и без особых достижений иметь право на публичность? Должно ли право на публичность передаваться по наследству? И если да, то как долго оно должно принадлежать наследникам? Должно ли право на публичность быть отчуждаемым? Должны ли кредиторы иметь возможность налагать арест на право на публичность? Должно ли право на публичность распространяться на изображение человека или также на его голос? Должен ли человек иметь средства защиты от использования похожих по звучанию модификаций? Должно ли это применяться к объектам, связанным с конкретными лицами, такими как хорошо известный гоночный автомобиль известного гонщика? 21 век уже видел, по крайней мере, один новый тип прав, связанный с интеллектуальной собственностью, и, безусловно, увидит еще больше. Широко обсуждаемый новый тип интеллектуальной собственности — это невзаимозаменяемый токен, NFT. Эти токены подключены к цепи блокчейн, чаще всего к эфириум. Однако NFT, хоть и основан на цепочке блоков, он не похож на криптовалюты эфириум или биткоин. который является взаимозаменяемым в том смысле, что одна единица любой из них полностью эквивалентна другой единице, точно так же, как монета евро эквивалентна другой монете евро. Но существует множество нерешенных юридических вопросов. Более того, остается нерешенным главный вопрос в отношении NFT и других новых форм интеллектуальной собственности, которые будут изобретены в 21 веке. Действительно ли они являются полезным нововведением или в первую очередь новым способом обмана общественности? Такое мошенничество уже давно является проблемой в традиционных формах интеллектуальной собственности. Например, самолюбивые издательства, которые обещают авторам славу и богатство за их работы, защищенные авторским правом, но которые в конечном итоге взимают непомерные гонорары за незначительные результаты. Или фирмы по оказанию помощи изобретателям, которые взимают с изобретателей-любителей большие суммы за бесполезные советы. Я обратил внимание на существующие и возникающие проблемы в системе интеллектуальной собственности. Как я уже отмечал, существуют возможные, иногда простые, иногда трудные решения данных проблем. В заключение я хотел бы остановиться на том, что является самой большой проблемой, с которой сегодня сталкивается интеллектуальная собственность. В мировой экономике более богатые страны, как правило, являются производителями и экспортерами интеллектуальной собственности, а также пользователями и импортерами сырья, в то время как более бедные страны, как правило, являются производителями и экспортерами сырья и импортерами интеллектуальной собственности. Дисбаланс был частично устранен политикой картеля ОПЕК+. Но в долгосрочной перспективе использование местных возобновляемых источников энергии в более богатых странах установит дисбаланс. С другой стороны, дисбаланс в сфере интеллектуальной собственности заложен в систему договоров об интеллектуальной собственности в целом, в частности, в соглашение ТРИПС Всемирной торговой организации. Во время пандемии коронавируса этот эффект был особенно очевиден. Богатые страны, такие как Япония и Канада, смогли оплатить импортные вакцины и добиться чрезвычайно высоких показателей вакцинации, в то время как более бедные страны Африки показали крайне низкие показатели вакцинации. Статистика Всемирной организации здравоохранения показывает кардинальную разницу в показателях вакцинации между богатыми и бедными странами. Нет сомнений в том, что система интеллектуальной собственности, наряду с государственной поддержкой фундаментальной науки, чудесным образом способствовала быстрому изобретению безопасных и эффективных вакцин, а также разработке новых лекарств для лечения этого заболевания. Трудная задача состоит в том, что нужно сохранить стимулы для изобретений и в то же время находить способы донести их до всех тех, кто восприимчив к этой болезни и ее регулярно появляющимся мутациям. Спасибо за внимание.
Well, let's give thanks to Mr. Meggs. And it's a pity that we cannot ask questions right now, but however, at the section headed by Mikhail Fedotov, we will have this opportunity, and I invite everybody to use this opportunity. And now I give the floor to the Director on the Human Rights Department, Saïdu Akhmalovu, and this will be related to the certain aspects of the improvement of the protection of rights and the interest of the subjects of the artistic activity. Thank you, Mr. Moderator, and I appreciate highly this opportunity to speak at this very high forum, and I believe that this is a part of the monthly activities on the copyright and intellectual property, and in this regard I would like to give my congratulations on the occasion of the International Day of Creativity and Innovation Activities. This day celebrated for the 5th time, and this was introduced by the General Assembly of the United Nations. And this day is related to the International Day of Mother Earth. And this day will be celebrated tomorrow. So this week, opened by Valentina Ivanovna, will begin on the 5th of April, the birthday of Leonardo da Vinci. And also, according to, because of the birthday of the famous writer Andersen, Hans Christian Andersen, this is the day or the week of the children's book, and also this is the day of intellectual property. So this is my introduction, and also I would like to mention that this year is the year of the intellectual property and the youth, innovations for the sake of the future. And I believe that our forum corresponds to this slogan. And as the moderator said, the topic of my presentation was, and my presentation was prepared jointly with Professor Akulov. He is one of the developers of the acting civil code of the Republic of Uzbekistan. But in my turn, I would like to talk about the development of the copyright and intellectual property and Uzbekistan, and then I would like to give more attention to the very interesting moments of the impulse report of Mr. Fedotov. First of all, let's talk about the copyright and the intellectual property in Uzbekistan. In Uzbekistan, we have developed the strategy of development of the intellectual property in Uzbekistan. We have created the system of legislation on the copyright and the intellectual property rights. We have the civil code, and the fourth part of this civil code is dedicated to the intellectual property rights, and there are 8 acts adopted about the intellectual property rights, and we are developing new approaches according to the model code of the CIS and the French code on the intellectual property rights. We are talking about the codification of the intellectual property rights in Uzbekistan. In parallel to this, we also work on the new criminal code, administrative code, and there are parts and chapters in these new draft codes on the intellectual property rights. We have signed 10 intergovernmental agreements on the intellectual properties, and in general we have more than 140 acts and treaties between different countries. We ratified the Berlin and Moroccan conventions, and we are the members of all Russia inventors and innovators society, and we have prepared more than 100 different books on this topic. And recently the new department of the intellectual property was set in the Tashkent State University. In different universities, the copyright and intellectual property rights are taught in the university. This is what I wanted to mention regarding the development of the copyright and the IP rights in Uzbekistan. And now let's get back to the impulse report of Mikhail Fedotov. Indeed, this report gives causes quite a lot of thoughts. And I would like to quote the classicals of the of different thinkers. I would like to quote Mr. Mayer, who was actually the tutor of Leo Tolstoy, and due to his tutorship, Leo Tolstoy made the conclusion that it is necessary to write a new book. And because of and what Professor Mayer wrote, the authorship remains one of the main dimensions of the freedom of human. In other words, the opportunities of the limits set by the legislation, and he wrote this in his book on the copyright. And in many publications and papers of the classical writers, the copyright is one of the main functions of the intellectual property right. And French lawyer, the author of the classical paper on the copyright in France, wrote, "The copyright is built on the central figure of the author as the person who has created the work of art. And he has the right, according to the general rule, all the rights of the creator of the work." And his work actually was published twice in Uzbekistan and in Russian. And it is very important. Also, I would like to quote Professor Gabriel Serchenevich, who had been quoted by Mikhail Fedotov. But it is important that Mr. Serchenevich gave the foundation to the individual and material character of the copyright. And the follower of this Kazan School of Intellectual Property is Professor Abdulin. Now he is at the European level, and I would like to call his papers as the comparative study of the intellectual rights in Europe. After quoting the authorities, I would like to express my agreement to you, Mr. Fedorov, that the general theory of authorship is not as yet recognized, and this is a relatively individual line of activities and research in the copyright research. And also I would like to mention several components in the general theory of authorship. First is the legal and norm aspect. What is the role of copyright at the level of international and regional legislation? And indeed, today we have the reliable legal foundation dedicated to the copyright. Second aspect is the international aspect. We have international organizations and regional organizations that are in charge of protection of the person of the author and the rights of the author, along with the court, because the court is a legal protection of the authorship. We have already 5 or 6 NGOs that work on the protection of the copyright and the author's rights. And the third component is the educational component, and the initiative of your department is very important. and end of your chair is very important. And because it is difficult for me to say now what are the works, except Mr. Dozortsov. And I think we have to engage much more young scientists who would give attention to this very relevant topic. And if you just mention different years, and I could give you different topics that we could discuss. Aspect number 4 is the monitoring. I would say this is very important because this will be the monitoring of the violation of the copyrights and the monitoring of the violation of the authorship, including the court protection. And another very important component is the role of the civil society institutions in the protection of authorship and the rights of the author. And I can say that today the role of the institutions of the civil society is growing. And the fifth, and also the international companies. Today, the chair of UNESCO and International Organization of Innovators and Inventors the institutions that should take the proper place in the general theory of authorship. And I believe that in the development of this theory, we have the civilizing approach to the theory of authorship, including the private law and the social law. By the way, we should remember that we have to remember about the constitutional aspect of the theory of authorship. And Mr. Fedotov was right saying that when we say that the freedom of creativity is the constitutional right, so we have to track what are the lines of constitutionalization of the general theory of authorship. This is a novelty, and in this regard I would like to present several conclusions. I presume that the authorship is a subjective, natural right of a human, has the constitutional character, is the practical, active right, and belongs to the first generation of the human rights, the personal rights. This is when we talk about the constitutionalization of the theory of authorship. Second, we can consider the authorship now as an individual legal institution, because it is developed by the norms of civil, criminal, administrative, family, processing legislations. And these are the complex of aspects in the theory of authorship. And this is a part of the general institution, constitutional institution of the rights and the freedoms of a human. And when we talk about the court and criminal parts, we have to consider that the court provides the protection of the rights of the author. And this is the freedom to go to the court to protect its right. And the second is to implement the constitutional rights through the court. And the level of the protection of the author's rights through the court is the indicator of the democracy of a certain society. And also, in conclusion, I would like to quote another important classical writer in the public law, Mr. Kochenovsky, Professor Kochenovsky, he wrote that the science is very profound, and the legal science is not for everyone. The legal science is developed by the most active and laborious generations, make input into the capital of several centuries. And I continue the quote of Mr. Kochenovsky, Professor Kochenovsky. This is another way to push the science forward, and this is very important for the self-esteem and very harmful for the uneducated persons. This is the art of present the merits of others, and I believe that this is the time to reevaluate everything critically. And now I have two practical proposals. First, in Uzbekistan, in our republic, in the second part of this year, we plan to hold an international forum with the topic the intellectual property in the 21st century. I would like to invite all the participants of this conference. We will hold this conference in a hybrid format, offline plus online, but we are very willing to invite the creative presenters from the Russian Federation to this forum. Second, the topic of the conference of 2023 can be named as the authorship, semicolon, national, universal, and this will be very brief, and everyone can find the topic for himself. And in conclusion, I would like to give the floor the quote from Antoine de Saint-Exupéry. In his book, The Little Prince, he wrote, "The most important thing for the humans is the communication." And I would like to express my appreciation for this opportunity of communication to all the organizers of this conference. Thank you very much. Thank you very much, Akhmar Khalmatovich, and thank you for your multifaceted presentation. And we will discuss your proposal at the final plenary session. Now I would like to give the floor to Kubishkin Alexei, Deputy Director of the Legal Department of the Ministry of Culture of the Russian Federation. And the name of the topic of his presentation is the transformation of authors' rights in the conditions of the technological development. First of all, I would like to give thanks to the organizers for the invitation to this conference, and I acknowledge and I appreciate the importance of this kind of conferences and the participation in such conferences, because the traditional values expressed in our civil code are seen from a different angle if you participate in such a conference. The topic of my presentation is the transformation of the author's right under conditions of the technological development, and this is related to the work of our ministry and the cooperation of our ministry with other institutions of the executive power in the Russian Federation. First of all, I would like to point out the routine work of the Ministry of Culture, because this is the regulate in the area of the related rights. If we talk about the legislative activities, it is not a secret that the acts, the legal acts that are adopted are related to the development of technology. And what is important is that we provided the development of the amendments to the civil code, and this is related to the development of our activities. And it is important to mention the additions and amendments to the civil code, and these are the additional legal acts on the standards of the information disclosure, etc. Everything can be found at the websites of these organizations. The Ministry of Culture took an active part in the development of the amendments to the civil code. And I want to mention another draft law related to the right holders and the providers of the internet rights. Also, I would like to mention our own Russian anti-piracy legislation. It has been discussed very closely at all the levels, and it is still under discussion. Mr. Boyarsky, the deputy from the United Russia Party, introduced the draft law last year, and I believe that this draft law will contribute to the improvement of the legal field in the authors' rights and related rights on internet. Also, among the latest drafts and projects, I would like to mention the draft law on the implementation of the international activities for disabled persons with sight and hear disabilities, in order to provide the proper access for these persons to the different works. And as we have an international conference, we're now at the international conference, it is important to mention the work of our ministry in international field. And this is carried out not only by the Ministry of Culture, but also this is a joint work with the Rospatent, with the Ministry of Foreign Affairs, and this is done both in the area of CIS, Eurasian Union, and in the field of international agreements. Among international agreements that were to be mentioned for the Eurasian Union, this was the agreement on the management and of the legal rights in the sphere of legislation on the territory of the Eurasian Union. This agreement already came into force, and we are now developing the necessary consultations and explanations to this legislation. And also our colleagues from other countries also ratified and implemented this law. Another important agreement that is being prepared now, prepared in the environment of our CIS countries. This is the agreement of the participating countries to protect the objects of the author's rights on internet. And also I would like to mention the institutions that the institution that was coordinating these activities of the Ministry of Culture and the Ministry of the Ministry of the Economic Development and the Russian Academy of Social Sciences also prepared, took an active part in this, and I would like to express my appreciation to these colleagues. And as to the international agreements in the International Organization of Intellectual Property, This is the topic of the author's right and the artificial intelligence.
It was last year that we conducted a survey among all the countries that are members of the World Intellectual Property Organization. And then, on the one hand, so the point was quite obvious. So when you approach the issue, the first time when you try and analyze, then you do realize that there are so many conjectures and there are so many questions arise as to what are the subject matters that should be treated as intellectual products. And we do know that in the Russian Federation there are many experts that believe that first we need an international approach and that this approach will then be rolled out across multiple jurisdictions. And we know that many examples have been cited as to the products that are by artificial intelligence and those intellectual products that are being considered and recognized as full-fledged items, and still it takes time. I believe that we'll be able to reach a common ground in this respect. I would also like to touch upon another project, which is National Program for Digital Economy in the Russian Federation. And so actually you can visit the website of the Ministry of Economic Development, and then this program includes 26 federal laws. So I just looked through them, those federal laws that regulate intellectual property. I think needs to be taken into consideration in the aspects that relate to self-executable contracts plus electronic means and instruments. So we know that the legal practice, so those are the tools that are to be implemented in accordance with the federal legislation. So especially transactions involving exclusive rights. There is mixed of opinions, because some people believe that these provisions will not be applied, and others see no obstacles to it. So just we're trying to analyze all the court cases that have been tried and litigated, just to see whether it's feasible and whether it's possible to apply those tools that are provided for the legislation. And there are two federal laws, again as part of the federal program. These two federal laws relate to the Russian Patent Agency in particular. And there is another aspect, the legislation that was drafted, and the work involved with the Ministry of Culture. So the drafted legislation, as far as I know, is under consideration by the Presidential Council for Codification and Improvement of Russian legislation, so that the draft legislation on exclusive rights actually took us 3 years to discuss all provisions in this legislation, and then the working group was made by the Presidential Council, and as far as I know, that now they have reached the final stage of their drafting work. So now it's up to formalities, so the way it will be submitted to the State Duma, which, as we expect, will happen soon. Another area of interest would be the systemic work between the Ministry of Economic Development and also the Ministry of Culture, so because we do have some plans to implement, and because the regulatory environment will be changing, so we need to also support the transformation of the business climate. And this digital transformation program includes lots of statutes and regulations, and it's in August. It's on the 8th of April 2022. So a decree or an order was issued to modify the regulation relating to intellectual property, and in its preamble, the document stated specific provisions or strategic elements, such as like the aims and objectives of the state policies to improve the competitiveness of national economy and ensure the growth of the gross domestic products, plus strengthening national defense across multiple areas and spheres, including intellectual property. So I believe this aim is very important. There's something that we should be striving for, and it has been supported by a set of objectives. Some strategic tasks for IP would include promotion, also the reinforcement of legal protection of intellectual products and means of the individualization, the next high involvement on intellectual products and actors, and providing an effective protection for IP rights, and also strengthening national defense mechanisms, and also enhancing technological independence of the Russian Federation. So just to name but a few. And so we are working in collaboration with the responsible federal authorities. So we will try and to achieve those objectives. So, and that brings me to the end of my presentation. Thank you so much. Thank you very much. And so we have seen lots of initiatives and projects, and I believe it is through our joint effort that we'll be implementing these programs and projects at the interdepartmental level. So Anatoly Vinogradov will be our next speaker, representing the International Center for Competition and BRICS, and also senior member and fellow associate of the UNESCO chair, intellectual properties and change of paradigm and reasons behind it. I'm going to address problems and broader strokes, just changing the paradigm. So this very phrase, so notion was coined by Thomas Kuhn, and who represented as several cycles that repeats a stable paradigm, then crisis, and a new paradigm. So when the crisis strikes and there are problems that will not be overcome if you rely on the existing paradigm. And then professional insecurity comes as a manifestation of a crisis, and it also breeds from something that was seen quite stable in the past. So Kuhn just described the law and then a dynamic of development and evolution. It was in early 20th century. Then we saw that was this post-stability periods that were just that culminated in crisis times. So law turns into mechanistic jurisprudence. Hence, there is a gap between law and reality. Just the law as it spells out, as it is spelled out in the books, and law the way that operates and functions in reality. So let's look at this paradigm in greater detail. Joseph Braxton from Max Planck Institute wrote an article on this, and then at the very beginning he wrote that intellectual property became a political battlefield. So it is about this economic competition between developed and developing nations. So that's because it was by another scholar. So it was India and South Africa that made this joint statement to hold the implementation of TRIPS provisions. That's the TRIPS waiver that has been supported by 30 developing countries, or 150 Nobel laureates, including the Pope of Rome. And after the statement, so the European Union, United States and Japan, all developed countries were strongly opposed to any kind of change. However, today the situation has changed, and there are talks underway between the European Union, India, United States and South Africa, and now they have agreed to just suspend patents for vaccination. Specialists, healthcare professionals, so they believe that we are not doing enough. So in addition to vaccination, we know that there are people actually suffering from this disease, and people who catch them, they will also need to bear in mind this treatment and medicines, all these aspects relating to the people's health. To me, it's a vivid example of those changes that are underway. Of a changing paradigm, can we bring it closer to the transformation of political landscape? I wouldn't say so, because it just all those conflicts that are related to the pandemic that would accelerate the paradigm. So the TRIPS and its waiver, so the standards are universal. So these are universal rules that create a system of intellectual property. And there are two major drawbacks. So first, if something is universal, then the state sovereignty will be diminished vis-a-vis national legislation on intellectual property. So TRIPS and other international agreements, so they limit governments and their rights to establish a system that would balance between strengths and weaknesses of national economies. Secondly, universality means universal rules for IP protection, and that's the case across the world, say in the United States. So this question was raised at the Congress level about the different patent protection regimes. So to have this differentiated approach, say you have one protection for mobile devices, and then you would have another legal protection regime for pharmaceutical products. So, but that differentiated approach actually failed, because a report was put together and then it was delivered in 2015. And the conclusion was that the fact that the United States was a member to the WTO, that meant that was a greater obstacle to modify the legislation, so there was no way around that. And we see that the universul approach that was considered so widespread in the past is now losing its positions, and we see that the landscape is changing, and also the purpose of intellectual property changes as well. So take mobile wars, so it was between 11 to 14, and then Apple and Samsung, so they just started lots of litigation across Britain, Australia, South Korea, Japan, and EU countries. Actually, I like the opinion of the High Court of England and Wales. So it was just stated that the cloud of litigation created the mist that led to this absolute uncertainty for the consumer. So these are the clouds and myths, so it's not about innovations, about competition in the markets. So the patents now function more broadly. The innovations, they just are at the background in strategical terms. So as for this transformation, I mean, it will be drastic when we will start rethinking our common approach and we'll start searching for new approach in the phenomenon of open licenses. So that this way, this paradigm has been undermined from the lower level. So it's just the grassroots level, and those involved in the relationship, so they initiate this program rather than lawmakers. So open licenses provide alternatives for this traditional model of licensing, and instead of limiting access, they would be extending it to the greatest degree. So just we have something similar to this alternative in the copyright field. And another example would be this constitutionalization of intellectual property. So the court, I mean, the Luxembourg court, I mean, just has been developing its approach to intellectual property and human rights, so on. So rights, the freedom of speech, the protection of personal data, and competition. So these are also basic freedoms that are enshrined in the Convention, and we definitely see a similar trend in the Russian Federation and the higher court that has been trying to strike a balance between the interests of market players, consumers, and manufacturers. So I'm supposed to cover the prospects because this paradigm and the changing paradigm relies on certain historical developments and events. Leonardo, for instance, would say that like changing priorities from individual to social ones, like attaching great importance to societal interests in the first place. So it was in the 20th century that we started to rethink the scope of exercise of certain rights, and most significant changes took place in the regulation of private ownership. However, back then, intellectual property was not mature, was not that mature, I mean, to undergo the transformation. So it was not affected by it, and that's my thesis, that just sort of backlash, and then this leg of behind the developments and just intellectual property is lagging behind the developments in the international economy, and I believe that we will see the social vector for intellectual products. So it's not about destroying the existing regulatory framework, so it's more of a systematic change in the paradigm. Thank you for listening.
Thank you very much for a very interesting presentation. This was quite innovative, and I believe that we will speak more about it at the following sessions. Now I invite the head researcher, Elena Perepelitsina. She is in the video connection, and I would like to give the floor to you, and I would want also to observe the following. We are behind the schedule, and we probably will have to reduce our agenda. Anyway, I ask you to observe the timing, and I give the floor to you. Honorable ladies and gentlemen, I would like to appreciate this opportunity to speak at this respectable forum. And my topic is the dynamics of the author's rights and how how this author's right is approached in my home Republic, Belarusia. The author's right, first of all, is very important because the human has been created according to the image of the God, and in any creation of the human, we are talking about the passion for the creativity. And many things that are used now in our everyday life is had been created by the people who expressed who were implemented some time ago, and quite often the author's rights were considered by different people in different times. And everything great was created to be kept in centuries. The monopoly for the protection of the copyright is related to the technological aspects of the civilization, and it is not always possible to protect certain rights of the authors. And I recall the music of the immortal Mozart that was accompanying the people who were sent to death in the Nazi concentration camps during the Second World War. And now the people feel the same necessity to get their creation protected. And in the countries of the general law, the copyright and the author's rights are seen as the general rights, and at the same time in the conceptual right countries it can be seen as the conceptual right. And anyway, we are considering this as something changing. The reality of the rights of the author's rights is quite changeable, and now it is quite different from the period when the author's right was born. Now in the material world, most of the human rights we are set to test the author's rights. These antinomies are overcome by different times. Elena, sorry, could you speak slightly further from the microphone? At present, the legal authors try to build new approaches based on the different approaches, but the author's right itself is changing, and the architecture of the intellectual property itself is also changing. I would like to say that in general, the Convention on the author's right was combined with different other conventions and covenants. And Russia joined this convention later in 1997, and the a contract on the author's rights in Belarus was implemented in 1998. The law on the author's rights were protected later, and the copyright is the result of the author's activities, and we don't have it is not important the volume of the copyright, and it includes both the volume of the copyright, and it can be implemented in any kind of the form. As to the violation of the copyright on internet is explained because it is very easy to violate the rights on internet, and the law on the related rights and the copyright does not take into account the specific features of internet. This medium remains, this environment remains very specific. And the State Patent Committee of the Republic of Belarus is the main body in charge of the corresponding policy and the development of the norms and regulations. And if we, for example, consider the different violations of the copyrights, this is, for example, the transformation of the artistic works into the electronic form and the placement on internet, and placement in different electronic and digital libraries, and this list of violations is quite similar to others. And also at the same time we have to take into account the fact that the violation of the copyright in Belarus is put on the users of the internet services. But on the other hand, we have to take into account the situation when an art of work is copied and placed in the memory of an individual computer and not placed on internet. And it is not yet considered. On the other hand, the norms related to the copyright and when it is related to the material rights, it is not always considered in the Belarusian legislation. And it is also very important to mention that the plagiarism also should be considered, and it is not yet expressed in the legislation. It is important also to mention that the problems can be mentioned in our civil and criminal legislation, but the problem is, the issue is that the norms in charge of the violation of the rights of the author sometimes contradict each other. We do not have special laws, but we have a legislation decree. This is the decree of the President of the Republic regarding the use of the information in the internet network. But it gives details on different issues related to the author's right and the to the author's right and related rights, but quite often the rights of the author are protected in traditional way, and it doesn't have to do with the virtual reality. In general, when we talk about the protection of intellectual property objects, sorry, Elena, we have to finish your presentation. Well, summing up, I would like to say that I don't work on the property rights professionally, like other people participating in this forum today. I feel the attraction of the author's right intuitively, and I believe that the author's right should be related to the objects when are felt by the heart of a person, and we have to pay attention to the autonomy of the of the author's right and digital technologies, and the right of each state, of each government, and the obligation of each government is to observe the necessity of certain works of art for the world, for the future, and on the other hand, the state should protect the creative works from violations, and it is necessary to allow or to prevent the use of these creative works and to provide high feelings to the users. Well, we have very little time left, and I would like to give the floor to the
доклад на пути к формированию локального интернета. Пожалуйста, прошу уложиться в тайминг, да, и быть лаконичным. Спасибо.
Спасибо за предоставленную возможность поделиться своими мыслями.
Thank you for this opportunity to
я понимаю, как импульсный, так я понимаю, импульсивный.
speak here on this conference. My presentation was conceived as the impulse presentation, and first of all, my slogan of my presentation is never make jokes with Mikhail Alexandrovich Fedotov. And as to the relation, as to the
можем вспомнить опыт, так сказать, даже наш сравнительно недавний, применительно еще до интернетной эпохи. Смотрите, 70-е, 80-е годы, как правило, борьба за доступ к информации, 90-е нулевые у нас изобилие информации, нулевые примерно 10-е это борьба с изобилием информации.
If we try to set the timing of different work with
борьбой опять за доступ к информации. Соответственно, эта цикличность повторяется, и, к сожалению, она может меняться с продолжительностью, но не меняется по сути.
The years 90s we were fighting and for the access to the information and the protection of the information, and now we have the availability of
попался мне недавно ролик на YouTube, когда-то давным-давно в рамках одного из
диалогов на одном из каналов, сейчас, правда, написано, что сайт нарушает законодательство РФ, поэтому уже боюсь его смотреть. Значит, было описано как раз-таки мной стратегия, что нужно сделать, чтобы построить в России железный занавес применительно к сети интернет. Это была абсолютно юмористическая тогда, по крайней мере, передача. Просто было сказано, что нужна своя доменная зона, нужно, так сказать, использование необходимых российских доменов для коммерческих предприятий. We were talking about the necessity to have the national domains, and actually the topic of that research on internet was that how to build the Iron Curtain again. Well, many years ago it was the hilarious, humoristic approach, but now it seems that it is more realistic. In 2014, a number of laws were adopted as to the protection of the personal data. In 2016, the Yarovaya law was adopted related to the counteraction to terrorism, and now we have the necessity to keep the data for a longer period. And actually we can say that the presumption is now that everyone is a terrorist if the opposite is not proved. And next we have the changes in the law on the communications, telecommunications, and the law of information. And now we have our local internet as to the connection. And the next stage is the law on telecommunications, and it is marked with the existence of the means of counteractions of the terrorist threats in adoption to all internet providers. So if the internet is disconnected from outside, we understand that the result is quite pessimistic. We understand that now we are going to have a state body that with the name of supervision, and it will be able to disconnect or restrict any potential website. And if before the theorists were talking about the possibility of the attack on a number of websites, now it is clear that it is sufficient to attack the only element, the center of counteraction to the threats, and through this center any impact on the Russian internet is possible. So, paradoxical as it is, this provides certain scenarios. And as a matter of fact, there was a historical moment when an unfriendly nation was undermining the activity of certain websites. So it took us 5 years to get quite close to the national internet, and as to the in the ranking of the approach to internet, we hold the 158th place, and China is on the 170th place. And now, summing up, I would like to mention today's picture. Internet provided quite a number of identification for the authors, and it is clear that the author of the 20th is not the same as the author of the 21st. And we have the very fast growth of the authors of the social media, including their own name or nickname, and it is not sufficient to just to hold their names or nicknames. It is necessary to develop a modern system of systems of consideration of these disputes. The electronic systems do not have sufficient temper, and it is all very important to take into account all these issues, and we believe that it is necessary to solve these issues. With this, that's it, and this is now I would like to give the floor to Ruslan Ruslanovich Budnik, and the floor is yours, Mr. Budnik.
Please try to be precise and concise. Just now the topic is NFT token, the subject matter of intellectual property. tokens, or whether it can be replaced or it cannot be replaced, and non-fungible, obviously if there is no value that it is non-fungible. Just these are the basics, but as of today I would like to note this legal relative nature is related to the transfer of rights for non-fungible tokens. You know, this relativism, or to me, lies in the following. So this system is very standardized, uses blockchain and smart contracts. So then you can use Creative Commons as a system of public licenses, which actually is not widespread at the moment, and this for the relative nature. So that manifests itself in this fact that we see a wide range of rights related to smart contracts. So you get your right, to use this copy, and then just ranging from this particular right just to the alienation and the assignation of all the rights related to the smart subject matter. So why are they buying so? And all people are buying, and that's quite business as usual. But why are they doing so? That's the question. And to answer the question, I think we should look beyond the legal field or beyond the aspects of law. But if we look beyond, then where to look for an answer? So we've been drifting towards this post-economic society, because you may be aware of the several conceptual strategies. You have this, post-industrial economy, and then, but I'm driving that we are going towards this post-economic society. So, and at a given point in time, in many developed nations, we know that this ownership interests have been fulfilled, and there are material resources. So these resources, they no longer define the trends in social development. So it's all about, this rarity of resources, because the economy is all about how to distribute the resources that are limited in their nature. So when we're looking at software, some software products, so these are not the attributes that go immediately with it. So it doesn't have an end, and it doesn't depend on the raw material or resource that you need to produce it. So you take this product of creativity, and its origin and source is not about being rare or something else. Again, I think so. Why they are buying so? They are buying it because the society we live in is just looking or searching for new values, something that is distant from the classic model of the economy, of resources being rare, therefore they have value. No, this is something else. So I'd tell this consensual value of creativity. So the very value of the product that has been created, it's because of the interest that it generates. It's like the economics of attention rather than information. And so we'll be translating so the ideas, and this will be done within the information field. So you may have tokens, and these popular tokens, that means that you have an affinity with the specific subject matter that has been produced. So once the token is there, then you'll be trying to disseminate. There will be no ban or prohibition to that effect. So the reason why is just to improve this, to enhance the value. So once this consensual value is strong enough, then you can decide it for yourself. Do you want to stay with the thing, or do you want to sell it to someone else? And this can be also seen as an alternative to the classic prohibition that we see under copyright. So this is what people are doing, and these physical objects are being destroyed in order to make a digital version of it and preserve, this very quality or being rare or unique. So other examples or approaches, so the NFT token could also cover tangible artifacts, and then it goes in a single lot. So the next evolution of concepts, so these are alternative apparel concepts, so within copyright. So we started in formula. So the first formula of copyright would be all rights reserved. Next, some rights reserved as part of Creative Commons. And not all the authors actually are interested in keeping stakes high, because sharing does good to them. It serves them also to increase the level of attention to their works. And now let's see how this plays out for NFT as it exists today in this existing doctrine of copyright. So in addition to this tangible rights or ownership, property rights, under smart contract, NFT would also symbolize this personal and intangible right of an owner. So the owner is well known, and he or she will invest into the token. It will boost the popularity, and it also enhance this consensual value. And by analogy, it's like a classic and personal, non-tangible right belonging to the author, or titulus, that comes from the Rome law. It's like an honorary title that is granted to the right holder and to the owner of the object, and then finally we see this truth criteria that is distilled through practice. So there are NFT tokens and there are metadata, and the sort of marker that owned by, that indicates a person who owns an object. That's a digital copyright to me. Thank you very much, and thank you so much for being so concise. And now I'd like to address all of our speakers and attendees. And actually, the first part of our intellectual marathon is over. It has been very exciting and insightful, and let me assure you that it's just the very beginning. So we have started, and then we'll continue our discussions and deliberations, and this will reach its concluding stage at 5 p.m. Moscow time. And before we go for a break, I would like to add one thing, that we have the second plenary session that starts at 5 p.m. and they also would like to have discussion with our impulse speakers. So for those from attendees, or distinguished attendees, if you want to raise your questions, so you are welcome. And then we will arrange discussion, Q&A sessions with all impulse speakers, Valena Stekanis and Anton Sergo and Akmal Said. So we have many interesting things ahead, and I would like to urge our speakers and to stay vigilant, because you'll be receiving many questions. I would like to add from the professionals, and by the way, this session itself will be moderated by Mr. Ivliev. And now it's break time.
Или потом угощать, что очень хорошо.